Good evening, this is John Milburn. This is part of our environmental law series, our planning and environment law series, and tonight we're dealing with strategic environmental planning and assessment. Last week we dealt with statutory instruments, regulatory tools in the context of ecologically sustainable development matters, and this week we concentrate on planning law. The emphasis is on strategic environmental planning and development control. This is really where things start to tie together. In terms of environmental law, the planning process is very important, and for the moment, although it will change later this year, in Queensland, the Sustainable Planning Act of 2009 provides the detail that you need to look at to understand the management of the process by which development takes place. The Sustainable Planning Act, or SPA, as we often call it, specifies how state, regional and local planning documents are implemented in practice. And you recall, of course, that Parliament creates these state, regional and local planning documents and then provides the executive with power to not only implement these, but also to create delegated legislation as well. So tonight, in terms of dealing with the planning process, we're really looking at the law as it's applied in practice at the executive level, the level where individual assessments are considered and processed. All right, there's a magic acronym that you need to know, and that is IDAS, I-D-A-S. You'll see it referred to in the Sustainable Planning Act, and it stands for the Integrated Development Assessment System. It's a process. And there is a definition of IDAS in the Sustainable Planning Act. Have a look at section 230. It provides the definition that this is a detailed process, an approval process for development. Now, there is an important matter that I need to clarify from the outset, and that is that if development is impact assessable, then the applicant may refer a dispute to the Planning and Environment Court. Otherwise, there is no scope to do so. And I say that particularly in the context of a submitter or objector, if you like, to a particular project. Okay, so think about those terms, IDAS, and think about it in the context of impact assessable development in particular. Tonight, I want to be practical. One of the best ways of being practical is to show you some websites that might provide some great online materials and resources. So let's start by looking at some SPA IDAS forms. To do that, I need to share the screen, which I'll do now. I'm working out which is the correct screen. Sorry. John?
It's a bit of a breaking up signal, John.
Yeah, I got a message saying that my internet is unstable, and I don't know why. It's just, I can't wait for the NBN to be rolled out in my area, but it won't be till next year. So, John,
I have the NBN and it drops out without warning.
Oh, I see. So it's not necessarily going to be the answer I'm after. Now, John, can you see the Department of Infrastructure, Local Government and Planning screen? Does that come up on your screen?
Yes.
Great. All right. I'll just see if I can make that a bit bigger. Okay, so here we have a link to the website, which deals with the SPA IDAS forms. And you'll see that these are approved under the Sustainable Planning Act, and the forms are listed below, starting with the form number 1, which is the application. And each of those are reproduced, nominating the date that they're effective from, and you'll see conveniently that they are in Word format. So by looking at the forms, you get a good idea of how the IDAS forms work in practice. Also, really importantly, have a look at the checklists, and you'll see that there's a comment there that if the development is not an assessable development, it won't require lodgement of development application, which goes back to an earlier comment before, that it's only assessable developments that we're looking at, and it's only impact assessable developments that we consider in the context of the Planning and Environment Court. Okay, so there we have forms that relate to applicants and forms for councils in terms of the procedures. So have a look at that. Under resources, I'll go up a page. So we're in forms and templates and checklists. Very slow internet, I'm sorry. And I went to the SPA IDAS forms. So just looking at that, if I go back to the IDAS forms, so now that you know where I am in this, let's have a look at the Form 1 application, which I'll bring up on the screen. And of course, it's landed on the other screen. I'll drag it up. And that's the way in which the application form looks. All right, so pretty simple forms to complete, but very important. The reason I'm showing you this form is I really want you to get a feel for how these things work in practice. The best way to do it, I think, is to look at the form, try to understand how it works in practice, and then you're on your way. There are, of course, the other IDAS forms that you need to consider. And for the applications, you must provide not only the appropriate form, but supporting information that's identified to accompany. And one way to do that is to look at the relevant state codes of the State Development Assessment Provisions, SDAP. And again, you'll see that in the same website, and you'll see the different ways in which the process works in practice. You'll see that this is prescribed pursuant to not the Sustainable Planning Act, but the Sustainable Planning Regulations of 2009. And again, we have different forms. So what I'd encourage you to do is go to this website, have a look at some of these web pages, actually look at some of the forms, and get an idea of how they operate in a practical sense. I'm just going to attempt to stop the share now, if I can. My apologies. I'm working on small screens and hard to see things, John. No, I'm not having much success there. All right.
I've got the glasses on.
Okay. All right. I think finally I got to stop the share. Okay, so that gives you an idea of the overall forms. Now, of course, the legal system works in conjunction with planning and environment law. We've been talking about the sort of higher levels. You might start at the start of the course. We were talking about international, then we filtered down to federal, then to state, and now we're really looking at almost a council level. But the forms don't necessarily refer only to day-to-day type applications. They also deal with larger scale applications. In fact, Parliament can sometimes bypass the procedures outlined in the legislation altogether and create specific legislation to deal with particular projects, such as the Century Code Development Act. The remedy is to lobby Parliament.
John.
Yeah.
Sorry, John, you sound like you've got a speech impediment.
Oh, is it that bad, is it? All right. Thanks, John. I'll try and speak.
Only at times. It seems to be fine, and then it just goes... Okay.
That's just the internet playing up. And I put on my headset because I thought that would make it as clear as possible.
When you said Century, were you going to finish with Century Mine?
Yes, Century Mine, yep. So there's specific legislation that applies in some circumstances, such as that.
Was Century Mine, because that broke up too.
Oh, okay, yeah. All right. So development applications, of course, may be the subject of litigation, and this occurs when the assessment manager, usually the council, does one of a few things. They might approve the development subject to opposition, or they may approve the development containing conditions, and those conditions can be opposed by third parties, submitters, or by the applicant, or of course the council could refuse the development and the developer appeals to court. So those things are all possible, and the ground of an appeal by a concerned citizen might include matters such as the decision made by the assessment manager was made in conflict with planning schemes. So if you're going to challenge a decision made by the council, you need, of course, to be aware of the planning schemes. And as I said, it's not every decision that's made by an assessment manager that is capable of being considered by the Planning and Environment Court. And again, just to harp on it, it has to be an impact assessable development. So watch out for that. Now, I guess you're probably saying, well, how do I find out what is an impact assessable development? The starting point, as always, is to look at the legislation. And in the Sustainable Planning Act, you'll see that there is a definition. It's Schedule 3, and it defines impact. Beyond that, to determine whether a particular application is impact assessable, check with the council planning scheme. That will typically refer you to zoning of land, and that will then indicate whether a particular application relates to a development that is impact assessable. For example, typically a residential subdivision is classified in the planning scheme as impact assessable. So when we talk about it being impact assessable, what does that mean? Well, we need to consider the definition of impact assessment. And again, we look at the legislation, and it says impact assessment means the assessment of certain things by the assessment manager, which I've said is normally the council, under section 314 of the Sustainable Planning Act, or if the chief executive is the assessment manager, by the chief executive under 255B and 314. And the impact assessment means the assessment of the environmental effects of the proposed development and the ways of dealing with those effects. Yes, John?
Excuse me. Your screen just went small and it says John Milburn's network bandwidth is low.
Oh, still. I just don't know how to improve it. I may have a 4G device, but I'll try and battle on if that's all right, John, but I hope I don't drop out like I did on one other occasion. Thursday nights seem to be a popular night for the internet around here.
It's still going.
It's still there? Okay. All right. We'll see how we go. All right, so if it's not impact assessable, then it can't be the subject of an appeal to the P&E court. But if it does go to the Planning and Environment Court, it will be usually a merits appeal. And a merits appeal is where the Planning and Environment Court steps into the shoes of the assessment manager and makes what we call the correct and preferable decision. The Planning and Environment Court is, of course, subject to its own rules, regulations, and it considers the application in accordance with legislation and case law. And like all litigation in Queensland, it's essentially adversarial in that the parties produce arguments to support either their application for or against the particular development or the conditions within that development. So when we talk about the Planning and Environment Court stepping into the shoes of the assessment manager, bear in mind that the P&E court must, from the outset, consider the same provisions, the same factors as the assessment manager does in initially assessing the application. And the Planning and Environment Court isn't there to consider whether the assessment manager properly considered certain matters and essentially review that decision. A merits review is a replacement of the original decision made by the decision maker. Okay, so whether it's the assessment manager or it's the planning and environment court making an assessment of a particular application, how do they actually go about it? Where do they look, and what do they give most guidance to? Well, at a state level, Queensland, there's a clear hierarchy. We of course have state, regional and local. And to reflect that, we have, from a planning perspective, state planning policies, regional plans and local government documentation. And you need to read them in that manner, in the sense that the higher up the list, the more weight the matter is given. So that applies to both the assessment manager and also the planning and environment court. I mentioned that the Planning and Environment Court has its own rules, it has its own regulations. You need to be aware of that, and we'll talk more about that in weeks 10 and 11. I mentioned before that the Sustainable Planning Act has its own regulations, like the Act itself, the regulations of 2009. And you need to be aware of those regulations because they outline and explain the classification of the type of development in Queensland. And when you're considering an application, you need to understand and identify the categories of assessable development. And the assessment manager must consider the category in assessing the impacts of a proposed development. And it's the status of the application that determines the IDAS process. So, for example, if the application is code assessable or impact assessable, different rules apply. If it's code assessable, that's CODE assessable, it means that the assessment manager must assess the development against certain things. They are what we call the common material, the applicable codes, and other relevant criteria. But if it's an impact assessable development application, the assessment process is more involved. And it's only in relation to those impact assessable applications that an objector, which we call a submitter, may appeal against the development decision to the Planning and Environment Court. So, as I said, the assessment development is either impact or code. A development permit is required for assessable development, and the Sustainable Planning Act regulates that class of development proposal. Now, I mentioned before the common material. What does all that mean? Well, the common material is assessment documentation. It includes reports and recommendations from referral agencies. And referral agencies, concurrent agencies, have a say in whether a matter should proceed or not. Other common materials are the planning scheme and local government instruments, relevant laws, if the assessment manager is not a local government, and the lawful use of adjacent premises or any other development approvals. Have a look at section 324 of the Sustainable Planning Act to get a better idea of what we're talking about here. Now, when a development application is required, the assessment manager is responsible for deciding about it. In Queensland, that's usually the council, but local government and local government generally will be the assessment manager. That is, if you like, for developments within a single local government area, and that's for most assessable development applications. But where the applications are broader in context and perhaps importance, where the state has jurisdiction, then the Chief Executive of the Department of State Development, Infrastructure and Planning is the assessment manager. So you need to be aware that it's normally the council, but sometimes it can be the Chief Executive, and that is where the state has jurisdiction. So what does the assessment manager do once it receives an application? Well, it makes a decision. It makes a final decision But in doing so, it can't make a decision that is in conflict with the planning regulatory provisions. If it does depart, it must show good reason to do so. There is one other thing that I want to show you on the website, actually a few, and one of them is SARA. It's what's called the State Assessment and Referral Agency, and it's a coordinated whole of government agency which deals with matters involving the Chief Executive. I'll just see if I can find it. I'll share the screen. Hopefully that has worked. And you'll see the State Assessment and Referral Agency, Sarah.
Yeah.
Very good, very good. And you'll see how that deals with the fast tracking of certain assessments, and it refers to the state planning regulations, sustainable planning regulations of 2009. So that's a useful thing to look at in context of development applications generally. There is a flow chart, and I'll just duck away to grab this. There is a textbook. I'll stop the share for a sec. There is a textbook that I haven't prescribed, but I'd really recommend, and it's not so much a textbook as a self-help guide, and it's really useful. It's this one. Now, I think there might be a later version of this. This is the Community Litigants Handbook. The one I've got is the 4th edition, and it's from the Environmental Defender's Office. It's not expensive to buy, but it's a really good resource.
That's the current one, John.
Oh, it is the current one? Oh, thank you, John.
Yeah.
Maybe I'm anticipating that with the new legislation, I'll bring out a new one soon. So page 28, there's a really helpful flowchart. And the reason I'm showing you that flowchart is that it helps you to make sense quickly of what is in the Act, a lot of words. Sometimes the flowchart just makes it so much easier. So if I get you to follow along from this, at the top it says, all right, we've got a development. First thing is, what type of development is it? And it can be exempt, self-assessable, compliance assessable, assessable development, or prohibited. Now, the one that's really interesting from our perspective, and the one where all the case law is focused, is in assessable development. So we really don't see a lot of issues in relation to the other 4 types of development applications. And then within the context of assessable development, it branches out into 2, code assessable and impact assessable. And most of the, if you like, the court cases relate to that stream of impact assessable. And that's where the development permit is required and submitters do have appeal rights. Code assessable, a development permit is required, but there are no submitter appeal rights. So have a look at that classification, and that's an easy way to follow what's referred to in the Act and the regulations. Now, I've been talking about a submitter. What's a submitter? Well, a submitter means a person who made a proper submission about an application. And you can have a look at Schedule 3 of the Sustainable Planning Act to see the actual definition. So if you like, an objector and a properly made submission, well, it must be in writing. There is provision for electronic lodgement, and there are time limits by which a submitter must lodge a document. Usually it's 2 to 4 weeks or so. And the most important part of the submission is to set out clearly the grounds the submitter is going to rely upon in court if the matter goes to court. Now, the Act provides for the possibility of what's called a principal submitter. In other words, the person who's identified as the one who's in charge, particularly where you've got a number of submitters who are collectively objecting to a particular proposal. And it means that the assessment manager can then deal directly with the principal submitter in providing things like a decision notice and dealing with time limit issues. Otherwise, it's pretty onerous with a lot of submitters for the assessment manager to deal with each individually. So the assessment manager makes the decision. How can a party affected by that decision deal with it? As I said, if the assessment manager approves the development, the decision notice is given to the applicant, and the applicant has an appeal period of 20 days. That can be extended, and it's during that period of time the applicant negotiates with the council regarding the conditions that have been imposed by the council. I'm saying council because typically...
Excuse me, John.
Yes, John? Yes, John?
Excuse me, doesn't it have to be made public so people are aware that they can object?
Yes, so you're right. Initially, it goes to the applicant. That is the first step. And the applicant has that appeal period. Submitters are not involved in that initial process, the first 20 business days. If the assessment manager, during the course of negotiations with the applicant, decides to change the approval, then they have 5 business days to provide a copy of what's called the negotiated decision notice to each principal submitter. And if the developer decides to accept the conditions or commence the appeal, then the assessment manager has 5 days to give a notice of that decision to each submitter. So have a look at sections 337 and 361 through to 366 of the Sustainable Planning Act. So to start the appeal, and you're right, leading up to all that, there are the advertising provisions and the notice provisions where it's impact assessable. So I've sort of kind of bypassed that, John, to go to the stage where the decision is made. So what happens if someone doesn't like... Yes, John?
Sorry, it seems that like not enough people know about it at the right time. But
Yeah.
if they really object, they're too late.
Yeah.
Like for example, our local council, with its LNP failed police minister, wants to build an industrial zone at the head of the river that borders the ocean and the river, and is less than a kilometre away from the turtle sanctuary, and they want to build an industrial zone there, and they're going, whoa, jobs and growth.
Yeah, I understand what you're saying. And I guess just so that I can't be political about it, but just remember, of course, that ecologically sustainable development deals equally with environmental issues and with social and economic issues as well. But I hear what you're saying. All right, so if we have someone who wants to lodge...
Sorry, interrupted again.
You're right.
That all these things seem to find a way to promote the development rather than stop anything bad. I mean, it's like, unless somebody objects, we're going right ahead.
Yeah, there's a lot to be said for that. And of course, I know that you watched that video involving Roger Curry, the environmental activist, and the work that he did in terms of a Paradise Dam. So it is possible. Actually, I think I've got a case for tonight or maybe soon, which is really interesting how someone took on, from memory, TAFE and got an injunction to stop them. I think it's in a few weeks' time, but I'll make sure that we identify that case. It's a really interesting case study about how someone just took on the big players and ultimately got a good result. So it can be done, but it's a lot of work, and it normally means someone or some group of people coming forward and putting forward the argument against the approval, and that's done through this notice of appeal procedure. So if you have a notice of appeal, it's lodged in the Planning and Environment Court, and there are certain opportunities for people to elect to be part of that litigation, but you do need to be pretty quick. You've got to file that within 10 business days of receiving the notice of the appeal. You can apply for extensions, of course, but just make sure of that. The other thing is that I should digress for just one moment and say, if you're involved in acting for a party that's looking to buy some property, then make sure that you do your searches, and part of those searches are referred to in the notes in Moodle. Okay, let's have a look at the share screen again, because I want to show you some flowcharts. And to do that, it's best if I show you on the screen. So you should be seeing this screen. I'm just going to go to Planning, and from Planning, so I've just hovered over Planning, I'm going to go to Development Assessment, which is really the theme for tonight. And I promise that we'll try and make this practical so you can actually see these steps in practice. So if we go to Development Application Steps, click that link, you'll see that there's some valuable information which is referred to there. There's also a thing called flowcharts. So on the left-hand side, if we go right down to the bottom, you'll see flowcharts. And here's where you get to answer some questions and get some answers. So this is talking about IDAS, Integrated Development Assessment System. It applies to particular developments, and all development is exempt development unless it is self-assessable, compliance assessable, or prohibited. But to answer these questions, you can determine whether you need a permit. So let's just put in some answers. Is the proposal an exempt development? No. Is it self-assessable development? No. Is it one that requires to be publicly notified? Let's say yes. Will the application involve a referral to an IDAS agency? Let's say yes. Is the application likely to involve an information request? Let's say yes. And we'll have a look at the flow chart. And from that, the website has generated a personalised flow chart with respect to that particular development application paradigm. So play around with that, understand it, understand these steps, understand the time limits there, 10 business days, 20 business days, 10 business days, and that's going to be so much easier than reading the legislation or indeed listening to me talk about it. So that's flowcharts, a valuable resource. Another place that you could look is, all right, I hope we're still there. You there, John? Not sure what happened then, John, but we're still there.
Still going.
Right,
Still going.
very good. We're just hanging on there. I'll just share the screen again because I want to show you another little resource that's pretty handy. And that is resources. So again, just at the top, we looked at planning before. Now we're looking at resources. And if we go to resources, we can have a look at development application steps and some other matters that are pretty useful. So tools, planning and environment court data appeals database. And here we have an opportunity to look at different appeals in different councils. I've chosen Fraser Coast, and we get a PDF with links in relation to appeals in that particular region with some results. So that is the, if you like, an appeals report. Okay. And I'm just going to share this screen as well now. I'll just drag it up because I mentioned before there's a hierarchy of steps, and that is the hierarchy of steps that we're talking about. So when we're considering the planning and development assessment system, we think about the Sustainable Planning Act, And we think about the state planning regulatory provisions, state planning policy, regional plans, and the standard planning scheme, Queensland planning provisions. Okay. So John, thank you so much for being the only participant. Have you got any questions? Because I think you did indicate that we could maybe have a look at some weekly problems.
Problem on week 5, you could put up some kind of explanation of the question and some sort of answer.
Okay, yep, sure. So was there
so I've been able to get through the others, but I look at that and go, huh?
All right, so in week 5, what was that to do with ecologically sustainable development?
I'm not sure. I've been working on the assignment.
Oh, okay. All right.
Man, I did look at it again, but I forget now.
Yep, sure. All right.
It's fluey.
Well, I'll just go through a few things to do with ecologically sustainable development. The first is, what does it require be taken into account, and what do governments and courts consider? So we know that legislation across the board now includes principles of ecologically sustainable development. And we know that it's a factor for decision makers to consider. And if it's a matter for them to consider, it's pretty easy for them to state those considerations without necessarily making it obvious that they've decided matters in one particular way or the other. But where they must consider the principles, there are some things that must be taken into account, such as the precautionary principle or public interest. So that process is pretty fluid. And in the text, you'll see, I think, a decision of Fell against Can Recycling, South Australia. The government overturned a decision to provide for refunds for recycled containers only where the containers were sold within that state. It also refers to merits reviews. So that was one part. The other part was to do with governance, sustainable development and good governance. And there are mechanisms. Have a look at market-based instruments, offset, structural adjustment, other economic incentives, which reflect the principle of improved valuation, pricing and incentive mechanisms. So that's relevant as well. And in terms of the way courts deal with sustainable development and how they draw on foreign judicial decisions and academic writings, bear in mind that there are some limitations, and the role of the courts in a merits review is fundamentally different to its role in dealing with judicial review. Tonight I've been talking about merits reviews. That's where they make the decision and they give weight to different principles, including ecologically sustainable development. In a judicial review, the court actually looks at the decision-making process to see if some way it's flawed, through, for example, through bias or considering irrelevant considerations. So keep that in mind, that difference between merits review and judicial review. John, that's a really flying overview of some of the things that you might want to consider in the answers to the questions for week 5. Has that provided any assistance?
I'll look at it again later. I'll listen to what you said again and see if I can make some sense of it.
Yeah, sure. It's been quick.
One question, again, you've shown us a lot of varied information, again, all these websites and flowcharts and things. Is it more directed at the assignments or the one to come, or is it exam type accessible?
Oh, it can definitely be exam accessible, or it can be for the assessments coming up. But really, I just want to make sure that you have access to resources that will actually give you some guidance and some help when you're using this subject in practice. So, yeah, you can say that everything that we do is geared towards assessment, but it's also flavoured with things that will hopefully help you in a practical way. So a bit of both. All right. Any other questions, John? Otherwise, I'll wrap it up. All good?
No, I think I'm good.
Okay.
Yeah, I'm a little bit, say, non-compos mentis this week.
Yeah.
So it's been a little difficult. I'm surprised I'm the only one here because I nearly didn't turn up either.
Right. Okay. I really don't like that situation of just talking on my own. And those of you that might be watching this later, please join us on a Thursday night, 6:30. Good time, easy, and we'll have some discussions.
I got off my deathbed for this.
Good on you, John. I hope everyone else is listening to that. I'm sure they are. All right. Well, I'll stop the recording now. John, thank you very much for attending, and we'll look forward to seeing you next week. All the best.